Good morning, everyone. You're very welcome to today's session on staying ahead of cyber threats for 2025. For those of you who don't know me already, I'm Julie Austin and I'm a partner in the data and technology team at Mason Hayes & Curran, and I help lead our cyber response group also. I'm joined this morning by three really great speakers. We have Anthony Strojan, who is a senior associate in our dispute resolution team and a member of our privacy litigation group. We also have Mandeep Gozal, who is the Vice President of Global Professional Services at Beasley Security. And then finally, we have Raf Sanchez, who is the Global Head of Cyber Services at Beasley Security. And we're really delighted to have the Beasley Security team here today to give us some really practical guidelines on incident reporting and incident handling. We have a great lineup for you this morning. So this session is going to take the shape of two separate parts. In the first half of the session, we're going to do a look back at 2024 and a look forward to 2025. And then in the second half of the session, we're going to look at a real life example of a security incident and get some practical insights from our speakers on what things are done well and what things are done badly in managing these types of incidents. Before we jump into the session as such, I suppose just by way of context and scene setting, it's fair to say that 2025 is going to be really, really groundbreaking for cybersecurity compliance. And that's because we saw a whole new maze of legislation introduced last year. So we had NIS2 and DORA. We also had the Cyber Resilience Act introduced in December of last year. And while that's very much gone under the radar so far, there's not been as much talk about the Cyber Resilience Act. That's going to place very significant obligations on manufacturers, distributors, and also importers of connectable hardware and connectable software. But stepping back from the law, I suppose the key aim of all of these pieces of legislation together is to ensure that there is a more robust cyber resilience across the EU and cybersecurity measures. And that's one of the key aims for the European Commission over the next few years. And that's a very commendable aim. I heard a report recently that cyber crime is going to cost the global economy over 23 trillion by 2027. So that's a really, really frightening figure for a lot of organizations. So before we start the session, there's just two pieces of housekeeping matters that I just need to attend to. First, we're going to do a Q&A session at the end of the webinar this morning, time permitted. So you'll see a Q&A box at the end of your screen. So please do pop your questions into that and we'll look at those at the end of the session. And then for those who would like to get CPD for attendance on this morning's session, you're going to have to complete a feedback form at the end of the session. So do remember to stay on and complete that feedback form. So I'm going to kick off the session. I'm going to look to maybe Raf, if we can start with you. Can you just maybe start by giving us an overview of the threat landscape from 2024? So what were the key threats that businesses faced last year?
Sure. Thank you, Julia. I think that was a great introduction to the issues facing organizations. And why should you listen to what myself or my colleague Mandeep have to say? Well, just to explain the context, Beasley Security handles about 5,000 incidents per year for organizations running from micro businesses up to multinational, very well-known brands, but also crucially organizations from lots of different industries and verticals. So the position we come at this from is essentially we see everything that's out there. We're probably one of the most frequently contacted organizations for these types of incidents. And here on the screen, you've got some very high profile summaries of incidents that would have been in the news. But I think the message we have is that the resilience that Julie mentioned at the beginning and the maze, I think is a good word that Julie used, of the regulatory and legal landscape is such that every single organization has risks and cyber risks. And the reason for that is that although we see these very high profile incidents, we also see attacks, we see data breaches, we see accidental losses, from every type and every size of organization. And the reality is the eye-watering amounts of money involved in cybercrime that, again, Julie quoted, are true, and it attracts people who would like to make money from organizations. So if we move ahead one slide, I think what I'd like to concentrate on, rather than these kind of big high-profile incidents, is the reality on the ground for any sized organization operating out of any territory, and whether you're regulated, unregulated, whether you worry about the Central Bank of Ireland, the DPC, or the UK ICO, these are all threats that organizations should be aware of. So these are some of the themes in that threat landscape, and Mandeep's going to talk to this further because he and his team really actually help organizations recover from these attacks. So what are we seeing? We're seeing increased attack surface. What does that mean? There are more services, platforms, resources exposed to the internet for a number of reasons. Organizations want to provide more services digitally. They want to allow their employees to work remotely or from a hybrid environment. So there's a lot more for attackers to see and potentially compromise. Then when we say sophisticated initial access vectors, sounds like a bit of jargon. Really, at the most basic level, what we are talking about here is the cybercrime ecosystem is the same as the physical crime ecosystem. In physical crime, you have people who specialize in burglaring houses, in high-profile jewelry heists or bank robberies. The same thing happens in the cyberspace. And initial access is the process of initially compromising or getting some kind of malicious access into an environment. And there are groups that specialize in that. Phishing is something that potentially you think of as a low-risk background sort of event. It is actually a key threat because it's a great way of getting initial access into an environment. And one of the key areas how these initial access brokers and initial attack vectors get access is through identity. And we really see identity as the next landscape, the next area where attackers are concentrating, because identities allow permissions into certain areas of an organization. If, for example, I receive an email from Julie, I'm likely to trust that more than from an unrecognized third party. So identity is really a key control measure and a control risk that Mandeep can talk to you more. The fourth bullet here really is about third-party risk supply chain, and this is kind of tied to identity. Organizations have to bring in third parties to access their data, process information, correspond with clients or employees. And in many cases, organizations are placing trust in those third parties where they maybe don't have the levels of control or audit that they would have on their own infrastructure. So this reliance on a network of third parties does expose organizations to risk. And the final point here really is about the cloud and the move to the cloud. And what we do see, unfortunately, is organizations believing that moving to the cloud means that their security responsibilities have also moved to the cloud. And if you kind of understand the GDPR and other legislation in this area, you can't outsource that risk, whether it's privacy risk or other regulatory risk. So there's a key issue here where organizations feel that there is less onus on them or less responsibility on them to really have a good understanding of how their data is protected in the cloud. So if you move on, I think then what I will do is hand over to Mandeep to talk a little bit more about why these risks are important.
Thank you, Raf. Thank you, Julie. So we've heard a little bit about how there's an evolving threat landscape. So what does that actually mean? It means the risks that organizations are facing are becoming more sophisticated, and therefore what we're seeing is the impact of those, the proliferation of those risks in reality to organizations. Organizations are struggling because one sort of cybersecurity strategy and application of risks in 1 month or given year may be completely redundant 3 to 6 months later, or in some cases faster than that. And the reason, we're saying this and we're having webinars like this is to raise awareness based on, as Raf mentioned, the 5,000 or so incidents we see every year. We only expect this to increase. So, why should organizations care about this evolving threat landscape? These sophisticated attacks, we saw 4 or 5 mentions of example risks, but identity and supply chain risks if I had to pick sort of even 2 out of the 5 are areas to really focus in information security, cybersecurity investments in controls and preparation and preemptive preparation. We saw through the pandemic with the rapid expansion of working from home, the firewall being sort of the original traditional perimeter edge of a corporate network, then moving to devices in home networks, meant that identity absolutely did become that new perimeter for organizations. And that's been exploited by cyber criminals, by groups out there. Maybe a more positive note from the perspective of first party security posture. We've seen generally because of ransomware as a service, what happened during the pandemic, organizations and sort of with the move to home working and hybrid working and the movement of that corporate network edge to the identity edge is sort of forced organizations to boost their cybersecurity investments and work with partners to work on that first party risk, the existing organization. But that blind spot, still exists of the hundreds, if not in some instances, thousands of suppliers that exist in an organization's supply chain. And where do organizations start with prioritizing, which of these hundreds, if not thousands of suppliers are key vendors that should be applied through due diligence in terms of risk assessments and controls that you would need to apply to manage events such as malware, which may start within your supply chain and through lateral movement may gain access to your organization, that first party I was talking about. And we see this, as Julie mentioned, through regulations such as DORA for financial services organizations and NIS2 from a wider base within the European Union, who are really driving for that operational resilience. So recognizing that's not a matter of if, but when, and when these events do occur to organizations, how resilient are organizations to reduce that time to recovery, if it's through a cyber insurance relationship, the kind of size of a claim, getting operations back up and running. So, there's real recognition across the industry as a whole that cyber operational resilience based on these threats, supply chain risk, identity, deep fake, initial entry vectors, it's evolving at a rapid pace. And these attacks are becoming more sophisticated. What does that really look like? Fraudulent transfers, I think Raf mentioned. There are a common way organizations can lose money, that's for sure, to scammers who impersonate suppliers or other third parties to have funds fraudulently transferred. We've seen a number of examples over recent months, if not years now, of CFOs, CEOs, board members being impersonated in real time, either from an audio or a video perspective on a Teams call, and sadly tricking members of organizations to transfer large sums of monies to bank accounts where they shouldn't be transferred to. So this is a real issue that we see and we support clients with on a daily basis. Business outages, from an insurance perspective, we provide proactive services, BZ security in combination with risk transfer insurance, but business outage, business interruption can have an immediate and devastating consequence on organizations, reducing or eliminating the ability to operate your business and service the needs of suppliers and clients and so on. Most of our clients have competitors who can swoop in and provide alternatives if they are down for even a few hours. Certain industries, including manufacturing, transportations, and logistics, have almost no appetite for downtime. So, what does that look like in terms of the tolerable downtime for a specific organization in your vertical, and what effective and appropriate controls do you need to consider to manage those kinds of extreme scenarios, which we're seeing more and more of each day? And look, just to say, attacks can impact organizations of all sizes. It's often a misconception that the big organizations with the data assets, the crown jewels, are targeted by cyber criminals. Yes, they are a target, but small organizations, mid-market organizations aren't necessarily safe because they're small or not a household name. This is a common misconception. The reality is cyber criminals will tend to sort of find a vulnerability that they can exploit, and then they will exploit that vulnerability across verticals wherever they find it. They're very opportunistic by nature. So this presents a real risk to organizations of all sizes. If we just move to the next slide, please. Thank you. There's a lot of example best practices through looking through the lens of the anatomy of an incident. And what I mean by that is, if you see the axis on the left-hand side, you can see there's we talk about initial access, when data then may be encrypted, if we're talking about a ransomware event, for example, and perhaps also where data can be exfiltrated outside of the organization's network. So these are sort of three core components of the anatomy of an incident. And across the top axis there, what are the sort of best practice preventative controls that organizations, we see and we recommend put in place preemptively and proactively, and also utilized during an incident, either in-house or through support from experts and suppliers, to reduce detection time, to reduce the response time during an incident, and also the time to recover and get operations back up and running, and in many cases reducing revenue loss, reputational damage, and business interruption. I'm not going to go through all of the examples on the slide, but certainly multi-factor authentication, scanning the network, running regular penetration tests, so in a safe environment, sort of almost trying to find the vulnerabilities before the bad guys do, and then patching those vulnerabilities when they're exposed and identified. Using principles of least privilege. So we talk about identity. So having policies such as conditional access policies locked down so that only those with accounts having access to data that they need for the right amount of time that they need access to the data have those privileges, rather than having a very flat network with everybody having access to everything. Can only bring challenges to that organization dealing with these incidents. EDR, endpoint detection and response. So these are essentially software agents deployed onto endpoints, laptops, workstations, printers, and so on, to detect anomalous behavior. So if there is a potential threat actor trying to gain access to the environment, or is already inside the environment and maybe trying to move laterally, endpoint detection or managed endpoint detection response solutions can help with early detection for those types of instances. Carrying regular tabletop exercises, these are really key to building muscle memory for organizations, kind of like a dress rehearsal. So even if very well written, well documented incident response plans exist and policies and libraries of policies and so on, but in the heat of the moment during a crisis, potentially the worst day of many people's professional lives, experiencing an incident or a ransomware attack, not knowing where to turn. Where is the policy? Who's talking to who? Where is the communications plan? So rehearsing and exercising and building that muscle memory in kind of a simulated environment is absolute, we think, table stakes, and all organizations should be considering whether they're doing enough of these tabletop exercises, and if they're tailored enough for the crown jewels and the risk context of organizations. And brass tacks, reducing recovery time, backups are so key. Taking regular and secure backups that are immutable, potentially are stored off-site, away from the original data, so that in the event, for example, again, you'll hear about ransomware a lot of times, still perpetuated as the number one kind of reason for incidents that we see. Ransomware threat actors are normally in the business of encrypting data and potentially even encrypting backups. So if backups are then encrypted, it makes it very difficult to recover operations, and can reduce some of the options available to organizations to get back up and running without having to turn to potentially being forced to pay ransoms and so on and so forth. So just move on to the next slide, please. So where are we regularly advising organizations to start? What are we seeing out there? We talk about prevention, preemptive measures, advisory assessments, taking regular and secure backups and so on. But where's a good place to start? Every organization is different. Every organization has its own individual attack surface. And by that, including your first party organization, the number of employees, endpoints, devices connected to your corporate network, whether they be in the office or from home, whether that be key suppliers that you think could pose a risk to your organization. How are you assessing those suppliers and applying risks? So starting with a cyber risk maturity assessment against the many industry best practice frameworks out there, such as the controls prescribed within DORA or NIS2 or ISO 27001 or NIST CSF. There are a number of best practice frameworks which have predefined the required controls most organizations should consider. Where is the organization from a gap assessment perspective against having those controls aligned to those best practices? So partnering with suppliers and service providers to carry out those independent cyber maturity risk assessments are a good place to start, providing the gap of controls, which then can lead into security roadmaps. So chunking down this kind of big task of securing your environment against these gaps identified into a program approach, a phased approach, recognizing that many organizations don't have, huge budgets to spend in very kind of short time frames. So making best use of that budget across a phased approach within a program to just sort of chip away at those control gaps over time. And then also recognizing over time that even the security roadmap might need to be adapted and refined and adjusted. And there are experts out there, there are organizations out there that can assist you with this task, and also recognizing that there isn't an endless budget and sometimes resources can be restricted. So there are partners out there to help you. So cyber risk assessments, creating security roadmaps, and then defining the kind of the types of tabletop exercises, the types of penetration tests, the types of training, reinforcing and evolving your security culture within your organization. There are organizations out there that can assist you with, by becoming your strategic security advisor and outsourcing a lot of that kind of pain management from a cyber perspective. I have a final slide to talk to, please. Just one more slide. Thank you. So just some tips on the slide here. I know there's a lot of text around. I won't talk through every bullet point. Building an effective incident response plan. So, we talked a lot about having a maturity assessment, building a security roadmap, but again, within, that anatomy of an incident, actually reacting to an incident and having that operational resilience. Where would you start in terms of building an incident response plan? Well, really, who would be within the incident response team within your organization? Who should be in the team? How would that team report to senior management, to interact with the IT team, the CISO's function? How would they communicate? How would you leverage cyber insurance provision if that's something you have in place and the services available to you within that cyber insurance provision? When would you utilize available experts, and in what capacity? So there's kind of a number of process points and communications points which should be documented clearly. And then also as part of that, conducting an incident threat analysis, determining how your organization will, define a security incident. So that might not look the same for every organization. So I think each organization has to have a strong understanding of identifying the thresholds which trigger a security incident for your organization. And also then creating quick response guidelines for different scenarios, be it short and long term, using your incident threat analysis and your organization's risk context and risk appetite. Create quick response guides for the scenarios you found to be most likely to occur and make them readily available for IR stakeholders. And by that, communicating your incident response plan within your organization, not only kind of a fire and forget and it gets sent as an attachment or a link in an email, but then continuing and reinforcing that cultural change through the IR plan, bringing it to life through tabletop exercises, through security training, through kind of nudging behaviors and banners and prompts that really get that critical thinking and sort of almost healthy levels of skepticism going within the organization, questioning that team score that might have come from the CFO with a huge sense of urgency to transfer funds, for example, as one example. Train, practice, and repeat. Learn from past mistakes. This is perhaps the most important driver of a successful incident response and security sort of cultural change within organizations, is to meet with all parties that handled previous incidents and to discuss what went well and what needs to be improved. All tenets as we see as part of, kind of pillars of a very solid incident response plan and an approach to cybersecurity. I think for now I'm handing back over to my colleagues Mason, Hayes and Curran.
Great, thanks Mandeep, that's really helpful. And there's already been a few questions if the slides will be available, because they're very helpful, and they will be. We'll make them available after today's session. So I'm just going to shift focus slightly, and I want to look at the civil claim landscape. So when the GDPR was first introduced and the right to bring claims for compensations for breach of GDPR was introduced, there was a concern that the floodgates would open. We'd see US-style class actions in Ireland on foot of data breach occurring. That hasn't been the case so far, but Anthony, can you maybe just give us a quick overview of recent developments on data breach claims in the civil courts?
Yeah, certainly. Thanks, Julie. Yeah, it's fair to say that 2024 was an interesting year in terms of developments for GDPR data breach claims, particularly in the area of non-material damages. There had been a couple of years prior to 2024 where the Irish courts were in kind of a holding pattern in relation to these claims. A number of circuit court proceedings were stayed by Irish judges. They were stayed because the Irish courts were awaiting some guidance from the European courts in relation to how GDPR is to be interpreted and how non-material damage claims should be treated. We were waiting quite some time for guidance from the European courts, but we finally started to get some significant judgments in 2023. The most significant of these judgments was probably the Post AG case that focused on the non-material damage claims. And there was really three core principles arising out of Post AG. The first is that right to compensation for non-material damage arising out of a data breach does not automatically arise by a mere infringement of the GDPR. You have to show the damage and the claim isn't actionable per se. The second principle is that there's no de minimis threshold for seriousness for these claims. It had been debated among lawyers prior to Post AG that a de minimis threshold should apply, that some level of seriousness should need to be proved by a claimant before they could recover for non-material damage, but the Court of Justice rejected that contention. And the third core principle that came out of Post AG is that the non-material damage has to be causally linked to the breach which has taken place, and that the claimant should provide evidence to that effect. In addition to these three main principles, Post AG also said that the assessment of damages for non-material damage claims in terms of quantum is a matter for the national courts. So that really put the ball back in the court of the Irish courts in relation to how they were going to assess damages for these claims. And shortly after Post AG, we got our first significant piece of judicial guidance from the Irish courts in the Kaminsky decision. That was a circuit court claim where the defendant was a food processing company and the plaintiff was employed by the defendant in a supervisory role in one of its factories. The claim arose out of an incident where the plaintiff was filmed on CCTV breaching food safety protocols, and this CCTV footage was then used in a training video where the defendant was basically saying to its other employees, "Don't do what your supervisor has done here," basically. The plaintiff wasn't present when the video was played, nor was his consent obtained before his footage was used in the training video. He was embarrassed and distressed when he found out about this. And it's also notable that the training video was uploaded to an unsecured employee network after it was shown, whereby it could be accessed by employees on a repeated basis. And this added to his embarrassment and distress over the incident. In the circuit court, he was awarded €2,000 for non-material damage. And following the Post AG decision, Judge O'Connor, in giving the judgment, outlined some principles which are to guide these claims before the Irish courts. He emphasized, first of all, the core principles in the Post AG decision, but just in relation to the de minimis threshold, the judgment said that mere upset wouldn't give a rise to a claim for non-material damages. The non-material damage must be genuine and not speculative, and that the plaintiff needs to give evidence in relation to the damage. The judgment wasn't exactly clear as to whether this should amount to medical evidence in relation to a psychological issue which arose, but there is a strong emphasis on evidence from the plaintiff being required. The judgment also touched upon apology being considered by the court when assessing damages, and also mitigation steps taken by a defendant where a data breach has taken place. The court also said that where a claim succeeds, the damages awarded are still likely to be modest. And in assessing the damages in this case, the court had regard to the personal injuries guidelines issued by the judiciary in 2021. And in considering the damages in this case to be on the minor level, which would equate to €500 under the guidelines, that's the kind of approach the court took to determining how much the plaintiff should be awarded. That kind of reference leads us on to another interesting issue, which was repeated in judgments in 2024, and this is whether or not these claims should be considered personal injuries. The Personal Injuries Assessment Board Act of 2003 requires a plaintiff to obtain an authorization from the Injuries Resolution Board, as it is now, before proceeding with a personal injuries claim. So if a claimant is bringing one of these data breach claims and hasn't obtained an authorization, they're potentially open to having their claim struck out. And differing approaches were taken by different judges in relation to this issue in the course of 2024. Some circuit court claims were struck out for a lack of authorization. However, other claimants succeeded in their claims despite not having this authorization. In relation to the latter category of claims, that may be because the issue wasn't pleaded in the defense of the claim, and it didn't arise on what was before the court. But it's an interesting question which remains open really in light of the differing decisions. In 2025, we're hopefully going to get some clarity on this issue. There's a Supreme Court case pending at the moment where the Supreme Court is considering whether or not these data breach claims should be considered personal injury claims under the 2003 Act. I guess the Supreme Court's kind of taking the view that the existing case law in determining whether or not a claim is a personal injury or not is not really suitable when we're talking about data breach claims and cyber incidents, which probably weren't contemplated by judges when the precedent cases were being decided in relation to prior personal injuries claims. In terms of the quantum of damages, we've seen differing approaches there as well. I just want to talk about two cases quickly in relation to the quantum of damages. The first is a High Court claim, Nolan and Dildar. This claim arose out of the breakup of the Nolan, or the breakdown of relationships within the Nolan Transportation Group. And the claim was before the High Court because it formed part of a number of claims in High Court proceedings. And in truth, the data breach element of the claim didn't really feature significantly in Justice MacDonald's judgment, but it's instructive nonetheless. Justice MacDonald awarded €500 to each claimant in relation to a data breach concerning the dissemination of pension information. And €500 is, it's a fairly low amount, and you could probably say that Judge MacDonald didn't see it as more than a nuisance value. Just a health warning in terms of this case and GDPR claims. The incident which the case relates to happened in 2013. So the claim was actually determined under the Data Protection Act 1988 to 2003. So it wasn't considered under the Data Protection Act 2018. But I think it's nonetheless instructive as to the kind of judicial temperature towards these kind of claims. Then towards the other end of the spectrum, there was a circuit court decision in McCabe and AA Ireland Limited. The facts in this case kind of bring to mind a cross between James Bond and Father Ted. The plaintiff in this case was out of work on sick leave. And he obviously had a suspicious manager who decided on his lunch break that he would hop in his car with a few colleagues and drive down towards where the plaintiff lived. And while he was in the car, he observed the plaintiff cutting branches on an overhanging tree for his mother-in-law. he decided he would record this taking place. And when the plaintiff returned to work, he was confronted about the activity that he was undertaking while on sick leave. He was understandably upset at being recorded surreptitiously without his consent. And the incident subsequently led to a disciplinary process being undertaken within the company. He was suspended and ultimately dismissed. Now, the company's position was that the footage that was recorded wasn't actually used during the disciplinary process. And the company also took the position that the manager had basically gone on a solo run, so to speak. There was no instruction to track down the plaintiff or record anything that he was doing. Despite this, the Circuit Court considered that the plaintiff's GDPR rights and rights under the Data Protection Act 2018 had been breached. And notwithstanding the fact that the footage hadn't been used in the disciplinary process, it did have some causal link to the circumstances leading to his dismissal. And because of this, the court decided to award the plaintiff €5,500. When we're considering cyber incidences and data breaches arising out of that, something that a company needs to be aware of is the multiplier effect and the potential exposure to liability arising out of an incident. And when you start thinking in that space, you're thinking, well, what's the upper limit of damages that we're exposed to, where each claimant could potentially obtain the upper limit. We got some interesting guidance from the Circuit Court recently in relation to this, where a data breach claim, which was noted by the court as being at the serious end of the spectrum, saw the plaintiff awarded €7,500. So I think, for companies who are thinking about what their potential exposure could be in the event of a quite serious incident where very sensitive information is part of a data breach, that's, for the moment, the kind of upper limit we've seen in the post-Kaminsky world. Another theme, kind of going back to Kaminsky, is the clear benefit for defendants in taking mitigation steps. It's been noted in a number of 2024 decisions that apologizing in early course where it's warranted will lower the amount of damages awarded, and taking steps in mitigation to kind of ameliorate the distress which might be caused to the victim of a data breach, that will be taken into account by the court as well. And there's just one other development that I want to talk about that happened in 2024, and that's the commencement of the Courts and Civil Miscellaneous Provisions Act 2023. As the name suggests, this was an act that was passed in 2023, but the provision which allowed data breach claims under the Data Protection Act 2018 to be brought in the district court was only commenced in 2024. That's important because, as you'll have noticed from the awards, in the circuit court cases, they're all below the district court threshold of €15,000. So by the commencement of this part of the 2023 Act, these type of claims can now be brought in a more appropriate court jurisdiction. The district court will obviously have lower costs. Now, the lower costs can cut both ways depending on how a case is determined. A defendant may be facing a lower costs order if they're successful in defending a claim. By the same token, a plaintiff mightn't be as afraid of bringing a district court claim because their exposure to costs if they lose wouldn't be as significant. So that's something to keep an eye on going into 2025 in relation to data breaches that are taking place now and into the future, is the venue in which they're brought. So that's probably the last hot topic to keep an eye on for 2025.
Thanks, Anthony. So my takeaways from that is that those decisions have been overall, favourable for organisations. We haven't seen significant fines, but look, that remains fine awards. It'll be interesting to see the HSE claims that are being put through at the moment as well on foot of the attack 2 years ago. Okay, thank you for that. We're just going to move on then to the second part of our session, where we're going to look at an example of a cyber attack, and we're just going to ask our panelists to discuss the issues around how to handle this type of an incident, and comment on what companies can do better when handling these types of incidents. I'm also going to do a poll on this case study, and I'm going to ask the participants to participate in that particular poll. So I'm just going to read the case study first. So in this example, we have a company who is hosted on a Microsoft Exchange server, and they suffer a ransom attack, which exploits an unpatched vulnerability on their Exchange server, and they enter into the environment. The threat actor encrypts the domain controller and encrypts backups. The organization then receives an email demanding a ransom, and then the threat actor claims that they have moved laterally throughout your environment and claims to have exfiltrated a large amount of data. So I'm going to pop up the poll and ask that you respond to these particular questions. So we talked about downtime earlier being one of the biggest issues for organizations. So in your view, is this type of incident going to have much of an impact on the organization? Will it paralyze the organization? And if so, for how long? The second question is this reportable to the DPC? And then the third question is, should the ransom be paid? And we will discuss these and give you the results of the poll at the end of the session. Okay. So firstly, one of the issues that needs to be decided here is whether this is a data breach. And looking at the facts, we don't know for sure whether data has been accessed, and we don't know for sure whether the data has been exfiltrated as claimed by the threat actor. And some organizations might leverage this to say that the requirement to report to the DPC hasn't been triggered as of yet. However, I suppose looking at this scenario, I think the DPC would expect the report to be made as soon as possible in these circumstances for a number of reasons. Firstly, it will take a number of days, if not weeks, to get answers to questions about what actually was touched on the system and whether data was actually exfiltrated. And while some time is permitted to do some investigations, in this scenario, the DPC would expect that a report would be made pretty quickly. Bear in mind as well that the DPC takes the view that the fact that data is accessible, will trigger the breach reporting. That fact that the data is accessible is in fact a data breach in itself. And that's arising from a decision from the DPC last year, where they held that the fact that passwords that were held in plain text, they were accessible on the system, but they weren't accessed. There was no evidence that they were accessed. They still said that that was a data breach. Also bear in mind here that, the data has been encrypted and that there is no backup. So that is an availability breach. So another reason why the DPC would say that this is likely to be a reportable breach. In this scenario as well, you often won't have a choice about whether reporting to the DPC or not, because you're more than likely going to have to tell your staff, and you're more than likely going to have to tell customers where the system is impacted to such a degree that, it's no longer operational. So then just moving maybe to Beasley team and Mandeep or Raf, can you maybe explain, from a business perspective and from an operational perspective, what are the practical consequences or implications like this from the business perspective? Is this actually going to paralyze the company? Is there going to be a significant downtime here given the fact scenario?
Yeah, and I think Mandeep can answer specifically about cases that he's handled and his team has handled, but practical implications are, and we've discussed some of them, but the reality is any cyber incident, in this case, we're talking about a malicious one, it can be an accidental, it can be a third-party compromise, are hugely impactful to organizations. They are not IT problems, they are enterprise-wide problems. They affect the integrity of data. So you have a regulatory and data angle and legal angle there. They may impact delivering customers services or products. So organizations are very worried about the impact on basically cash flow and their ability to sustain ongoing operations. I would also highlight the human element. If we're talking about an exchange server, we're talking about emails. We're talking about unstructured data. It's a huge amount of information about individuals in the company, their clients, employees. So we often see organizations suffer tremendously. People will leave, people will retire early. So there's a huge impact on organizations outside of the kind of technical and operational measures. But you have described, Julie, the worst case scenario. Even scenarios where you do have backups, even scenarios where there may not be encryption are hugely impactful. And so I would say, yes, this is the worst case, but even in lesser cases, the impact on an organization and the individuals there are really, really bad. And my approach and our approach at BC Security is when we have organizations approaching us, they will have questions, just as you raised, Julie. Is this going to stop operations? Do we have to notify? Who do we have to notify? And our crucial advice is always talk to the experts. You need to talk to lawyers. You need to talk to IR professionals. And Mandeep is one of those IR professionals, and his team give some of those insights. And maybe I'll hand over to Mandeep to carry on that stream of thought.
Yeah, and look, the organizations, I think kind of Raf mentioned, not only the organization, but the individuals working within that organization is having to deal with that incident. There's a psychological element to it and that experience. I think I mentioned sometimes it can be the worst, professional day in that individual's lives. They don't know, the CEO or the member of the board or the CISO or the person working in IT, are they gonna still have a job at the end of this? There's a real psychological stress to the incident, as well as the impact on business interruption to the organization. But to kind of Raf's point, I think it's a team effort, right? And what we mean by that is there's advice and knowledge from a range of subject matter experts to support organizations to navigate these complex events. And the kind of the shift in psychology, I think, that we've seen over the last few years, and sort of acceptance of it's not a matter of if but when, is these events are so common. These cyber criminals are opportunistic by nature. They find vulnerabilities that they can exploit. They kind of stick to them, and they will just try and exfiltrate data and sort of get within as many organizations as they can, no matter how big and small they are. So these are very complex events. These are very stressful events, and they have regulatory, privacy, data, technical, forensics, chain of custody elements to them. And sometimes perhaps maybe on the softer side, if you like, communicating internally, communicating to the media, the press, journalists become all of a sudden very interested in what's going on inside an organization, when perhaps there's a potentially leaked update on social media from an employee, or someone sort of catches wind of something happening, an incident an organization's dealing with. Even if there is the most well-rehearsed and well-written incident response plan and communications plan that an organization can have, there are a range of subject matter experts, legal counsel, communications, PR, crisis communications management, cyber insurers, digital forensics, restoration experts that can act and behave in a seamless way to support organizations to recover from these incidents. And in the heat of the moment of that crisis, they can very quickly, with a very calm and cool head, working in conjunction with legal counsel and PR and crisis management, help the organization to determine the most business critical services and service applications that need to be restored and recovered in the shortest space of time to reduce that kind of business impact and bring operations back up and running. So the good news is there is help out there from a range of experts, and even better news is that organizations like cyber insurers and law firms have come together with digital forensics firms to provide that end-to-end comprehensive support for organizations during these incidents.
I'm actually looking forward to see the results of the first of the question about how long it will take the business to recover from this, because I do think that businesses underestimate the time for getting back up following an incident of this nature. So it'll be interesting to see those results. So can you give your experience then on, what are some of the key mistakes that you see internal security teams make when they're trying to handle an event like this? Can you give some practical tips on that? or Raf?
Sure. And I think the word mistakes suggests that there's a right way to do things. I think the reality is organizations and the stakeholders involved are usually, acting with the best intentions. They're trying to recover their organization. However, security costs money. And so, decisions are made usually way before an incident occurs about how infrastructure is set up or how services are set up, and in a way that's not ideal for the teams helping, whether it's lawyers or forensics investigators or crisis PR experts afterwards. But there are a few issues, I guess, that we do see occurring again and again. And one of the key things for us is we talk about recovering a business. Well, if Mandeep's team is coming in to help a business recover, what we ideally want to do is ensure the incident is contained, that the threat actor has been ejected. And to do that, Mandeep's team will need evidence, right? They will need to understand, when did the threat actor get in? What did they do when they got in? Whose accounts did they compromise? Because often we will see organizations that have backups. However, if they have a threat actor in the environment, they do not want to allow their clients to access services until they know those are clean. So actually some small steps, like really engaging in an assessment of how frequently logs and other information evidence on appliances is cycled or deleted, is a huge benefit, for potentially a small cost. And that's why engaging with, firms, whether on the legal side or, as Mandeep was saying, in terms of assessing early before an incident occurs, how they can improve their threat posture is so important.
I agree. And just to add to that, from a preservation and retention of logs can not only assist and support chain of custody and forensic preservation of evidence, but also aid investigations to maybe provide a view of how long a threat actor may have been resident within the environment, and then the immutability of a backup, depending on how far back the backup was, how long ago the backup was made, in terms of the integrity of the backup. One other kind of tip, just briefly, in terms of engaging with threat actors directly, if it's a ransomware scenario. Again, we provide advice. We won't prescriptively tell kind of clients what to do, but we provide our advice based on our experience. But there are other specialist firms such as ransomware negotiators that are experienced in dealing with threat actors in an opaque way, so inserted between the client and the threat actors, to essentially engage with, and if necessary negotiate with the threat actor, with the starting point of paying no ransom, right? This is the aim, not to kind of fund criminal activity, but in some cases, that assistance is required, and not engaging sort of too early or feeling under such pressure, which is an easy thing to say, in the heat of that crisis, and people aren't generally experienced with being sort of blackmailed with paying ransomware notes from cyber criminals, but raising awareness that there are subject matter experts and specific consultancies that can help to support you during those incidents.
And you mentioned evidence and logs, and just one thing, I suppose, from our perspective, when we're dealing with the DPC, it's a question that they're always raising. They're asking us about log policies, retention periods, and it's a question that, it's very hard for clients to answer, because they haven't reviewed their policies about retention of logs, and they don't keep them for long enough. And just to flag, it did come up in the Centric Health decision with the DPC, I think last year or the year before. They, performed a system reset when they had a ransomware attack, which had the effect of destroying a lot of the logs and evidence of what the intruder did. And the DPC was very critical of that within its decision. And like that, they were trying their best to handle a situation. But, that's something that a real practical tip that can be, a takeaway point. You mentioned engaging with ransom negotiators, so we'll finish with this point, and we'll try and take some time to do some Q&A. So one of the questions here is whether or not you should engage with a threat actor, or whether you should pay the ransom. And I know practitioners in this space have very conflicting views, and it is a bit of a minefield in itself. And some of the issues, I suppose, that businesses need to consider, or organizations need to consider, are, if they pay, are they going to be targeted again by the threat actor in a re-extortion attack? or if it becomes public knowledge that the organization has paid, will they be targeted by another threat actor? Also, some other considerations are, if we pay, does the decryptor key actually work, or will it work fully? Other considerations are, is it actually legal to pay? Are there any sanctions that are in place on the threat actor or on the group? But I do, and just on that point, I know there is a proposal in the UK actually to prohibit the payment of ransoms by public sector organizations and those operating in the critical infrastructure sector. So that's interesting to see where that will go. I do agree with you that you should absolutely engage an expert in this field. We had a situation there last year, and we worked with a specialist ransom negotiator, and they were able to give our client really, really helpful information in relation to the specific threat actor. And they were able to use that information and make an informed decision on whether to engage or pay. So, for example, they were able to give stats on the average payout rate for that particular threat actor. They were able to give stats on the data recovery rate, which in that case was over 90%, so that there was a strong prospect of getting the data back in that particular case. They were able to say what the average negotiating time with that particular threat actor would be. Obviously, that's going to vary. They were also able to say that this particular threat actor didn't have the practice of re-extortion. So all of these really, really useful pieces of information were absorbed very quickly by the senior executive team in that organization, and they made a decision almost immediately. They were also able to tell us that this threat actor, in that particular case, on average was demanding 1 to 5% of annual turnover, because they didn't actually make a particular demand, so we didn't know what the ask was going to be. So I think that is a really good tip. There's probably other benefits for engaging with a threat actor as well, even if you don't propose to pay. Sometimes by engaging with them, you get a little bit of information. You get to understand what data they actually have, because if you're going to be engaging with them, you're going to want to request proof of life as such. You're going to want evidence that they actually have your data. So they will be giving you records or a report on what data they have. So it can be really useful from that perspective. Ralph, I know you could speak about threat actors and whether you pay ransoms at length. We are probably at end of time, but if there's 1 or 2 points you want to make from an insurer's perspective, I'll hand it over to you for maybe 1 minute, half a minute.
Connect with the experts. The questions you asked, Julie, are questions that should be in an incident response plan or other crisis management documentation internally. We don't want to be thinking about questions at the event. Connect with the experts. Mandeep's team, if they're doing an IR, will say, hey, we need 9 days to find you an initial point of access and a date when the threat actor got in. That's what you can have as a deliverable from the threat actor. 9 days of time to understand how the IR team are going to help you recover. So I'll just end it there in saying, connect with the experts, and that's where you get the most value.
Okay. Right. Will we take 1 or 2 questions before, I'll actually just give the results of the poll first for that particular scenario. Okay, so the impact of that particular scenario in an organization, 54% said significant impact weeks and months. So that's good to see. And I think that would be correct. So is this breach reportable to the DPC? Okay, 97% said yes, 3% said no. Kind of expected those kind of stats. And then should we pay the ransom? No, 89%, and yes, 11%. I'd be interested to see if I ask that question again, now that we've spoken about it, what the result would be. Okay, let's see. Any quick questions that we could take here? So does it make sense for firms to arrange cyber insurance so costs and expenses incurred after an incident are recovered from insurers? Ralph, is that something you want to take?
So, you used the correct word, Julie, at the beginning of this event, which is resilience. And I think Mandeep used it as well. Cyber insurance is a tool. It's a thing you can use to help your organization be more resilient. And it encompasses a bunch of services. It's not just about the risk transfer. So that's what I'd say is the value of insurance.
Great. Okay. Are there any other questions there that anybody wants to take that will be quick?
Julia, I just see one there in relation to, if there's visibility on the volume of data breach claims following the Kaminsky judgment. The short and unfortunate answer is that there isn't great visibility on the volume of claims. This is mainly due to the siloed way in which district court and circuit court offices operate. There's no central repository where you can check how many of a certain type of claim have been brought in a given year or against a given defendant. So any visibility we have is through judgments and anecdotal evidence in relation to certain breaches. For example, the HSE breach, which you mentioned earlier, it was reported in the media last year that the HSE was in receipt of hundreds of claims arising out of that. But beyond those kind of incidental and random reports on certain defendants, we don't have a great overview of the volume of claims.
Okay. But certainly not, we're not expecting US style class actions at the moment. I think that's fair to say. Yeah, good. Okay. Well, look, that probably, we've run out of time. I know there are other questions and we can follow up with those people after today's session. I just want to remind people to complete the feedback survey so that they can get their important CPD points. And then I just want to thank Mandeep and Raf for joining us today. You guys were super in terms of bringing the practical experience to the session, and Anthony as well, to thank you for participating in the session today. I hope everybody enjoyed it. Do fill the feedback form out and we will be in touch with all of you soon. Thank you.